Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide in this podcast is for informational and educational purposes only. I am not providing legal advice. This is not a consultation, and nothing in this podcast should be construed as creating an attorney-client relationship. I hope you feel like we're building a relationship as we talk together through this podcast. I welcome your feedback, and if you would like a one-on-one consultation with me, go ahead and click the links in the show notes and schedule a consultation. So this week we're talking about trademarks, maximizing trademark protection. And in this episode, we're in season 13 on the IBGR network, and we're on episode 15. We're going to talk about the TM versus the circle R and important trademark usage tips. So did you know at the start of COVID, or since the start of COVID, trademark filings have more than doubled. And the wait time for a federal trademark application has also more than doubled. Timing can be critical when launching a brand, and understanding the process and how to ensure you have exclusive rights to a trademark will help you make good business decisions. And let me talk for a minute about why the trademark office why did filings double? Well, with COVID, so many people were at home and they had the opportunity to connect to the world through the internet. And so more and more people were connecting to the world in business through the internet. And when you're selling through the internet, it's much more likely that you're going to consider, I need a trademark to distinguish my brand from all the others on the internet. It doesn't feel as necessary when you're selling locally because there aren't all those brands locally that you're competing with. But so many people made the transition to selling online, whether through Amazon or other platforms. And there was this boom of trademark filings in the United States Trademark Office. And they've been able to maintain and get it at a steady state, but they still haven't gotten rid of the backlog. So for the moment, we're at like 9 months is often what's happening right now for the wait time for the trademark office just to look at your trademark application. Before COVID, it was 3 or 4 months. And so now we're at 9 months approximately. And so as I mentioned before, good research is important, and waiting 9 months for the trademark office to do their research might be too long for your plan with your brands. So working with a trademark attorney that can do some good research, can give you a really good idea of what's going to happen, what kind of risks are out there with your brand, so that you aren't waiting 9 months to hear what the trademark office says. We'll have a good idea before you file, and then we'll find out if they agree with our assessment down the road. So how do you use trademarks? When you don't have a federally registered trademark, you can still mark TM. That means you're claiming trademark rights. SM is for service mark if you're doing services. And that's perfectly acceptable and encouraged to put TM on your branding when you don't have a registered trademark. And since trademarks are specific to each country, some companies that are selling into multiple countries might put that TM even when they have a registered trademark in one company, so they won't have a problem with marking something with a registration and then selling it into a country where they haven't obtained that registration for that trademark. So that's some of the reasons you might see TM, even on a brand you would expect to have been protected in the trademark office. Now, after you filed for a federal trademark registration, but it has not been granted, you don't have a registered trademark, you still need to use that TM. And you can use that circle R and put it next to your brand when you have your trademark certificate. So that's the usage, how to use it. And there's no real harm in putting the TM next to whatever you want to claim as your brand. It's a really good practice because it helps others identify that you're using this as a brand. As we talked in a previous episode, if you've got a brand that is on what the trademark office might consider the weaker side, it's highly descriptive, you can still be putting the TM next to that and establishing that as a brand, letting other people know this is our brand. So one other thing to let you know is there are a lot of scams around trademarks. When you file a trademark application, some of your information will be made public within a day, usually 2 at the most. And there are scammers who use that information and they send information that they'll send things that look like they are official from the trademark office or another country's trademark office. They have confusing fine print. And one of the big advantages of working with an attorney is that, or at least our firm, you can always send us your trademark correspondence. If you get something in the mail, get something by email, wherever you get it from, and it looks like it's something you need to respond to, send it to us. We'll take a quick look at it and let you know. Even if you're not a client, schedule a consultation. We'll look at that together. If it's a scam, we'll let you know. Don't waste your money. Throw it in the garbage. If it's something you actually need to take action on, we'll let you know that as well. So with proper use of your trademark, you don't want to use your trademark as a noun. So an adjective only is what you want. If you look at the bottom of Kleenex tissues, so this one's actually that I've got here at my desk, a member's mark, and it has the little TM next to it. And then it says facial tissue. The same thing is done with Kleenex brand. They'll have the word brand, and you can put the word brand instead of the word TM to make it really clear this is a brand. Kleenex is one of the companies that's had great success with their Kleenex brand, almost too much to where people refer to the tissue as a Kleenex, but that's actually a brand. So they have to be very careful with their brand not to educate the public that this is a Kleenex, but it's a Kleenex brand facial tissue. You want to do the same thing with your trademark. Don't tell your clients or your customers to use your trademark as a noun. You can be ruining your opportunities to enforce your trademark if you're doing that. Train your employees on the proper use of your trademark. Sometimes things get away from you. This happened to Apple. There was, they applied for a trademark and it was called live photo, and they weren't able to keep control of everybody using it, and the term live photo became a term that everybody was using for what it was, not who was offering. So the case went to the Trial, Trademark and Appeal Board, and they found that it was generic. It ended up being highly descriptive and moved over to generic by its use, as everybody was using it. Especially when you're dealing with trademarks that are more descriptive, be very cautious and have training with your employees. This is our brand. Only use it as an adjective, as a source identifier. And that will help strengthen your brand. It will help your employees understand what you're building with your brand. And that can save you a lot of headache and trouble. So with brands, there can be multiple brands that have the same name but are not confusingly similar. An example I looked up many years ago was I found that there was a moving company called Trico, Trico, long distance movers. And I found another company called Trico, Trico, that made automotive parts like windshield wipers. And then I found a third company called Trico, Trico, that's an electric company, an electric cooperative. And because these are such different markets, different offerings, people are not likely to be confused about these three companies. They don't expect an electric company to be offering moving services. They don't expect a moving company to be manufacturing and selling windshield wipers. So it can happen that trademarks, even though they're very similar, can still be kept separate or even the same name if they are in separate categories. So don't risk losing your trademark rights, and contact us to schedule a free consultation about your trademark strategy. I'm Wayne Carroll, and this is Leveraging Inspiration.